The best operating agreements for your business in Creek County clearly explain ownership, management authority, profit sharing, decision-making, dispute resolution, and what happens when an owner leaves, dies, becomes disabled, or disagrees with the other owners. A good operating agreement should not be treated as a generic form that sits in a file and is never used. It should be a working document that protects the business and gives the owners clear rules before conflict develops. Clear ownership terms. A strong operating agreement should clearly identify who owns the company and what percentage each owner holds. It should also explain what each owner contributed to receive that ownership interest. Contributions may include money, equipment, property, services, intellectual property, customer relationships, or other value. Ownership should not be left to memory or handshake agreements. If one person believes they own half the business and another believes ownership depends on capital contributions, the dispute can become expensive. A clear operating agreement reduces that risk by documenting the ownership structure from the beginning. Management authority. The operating agreement should state whether the LLC is member-managed or manager-managed. In a member-managed LLC, the owners run the company directly. In a manager-managed LLC, one or more managers have authority to operate the business. This section should also explain who can sign contracts, borrow money, hire employees, open bank accounts, buy equipment, enter leases, settle claims, and make major decisions. Without these rules, one owner may bind the business to obligations the other owners never approve. Voting rights and decision-making. The best operating agreements explain how decisions are made. Some decisions may be made by a simple majority. Others may require unanimous consent or approval from owners holding a certain percentage of ownership. Major decisions should usually receive special attention. These may include taking on debt, selling company assets, admitting new members, changing the business purpose, purchasing real estate, entering long-term leases, changing tax treatment, merging with another company, or dissolving the business. Profit distributions. An operating agreement should explain how and when profits are distributed. Some businesses distribute profits based on ownership percentages. Others may use a different arrangement because one owner invested more money, one owner works full-time, or the owners agreed to reinvest profits into the company. The agreement should also explain whether distributions are mandatory or discretionary. A business may need to keep cash for payroll, taxes, inventory, insurance, equipment, debt payments, or expansion. Clear distribution rules can prevent one owner from demanding money the business cannot afford to pay. Capital contributions and future funding. A good operating agreement should explain what each owner contributed at the start and whether owners may be required to contribute more money later. If the business needs additional funding, the agreement should explain whether the company will borrow money, accept new contributions, issue additional ownership interests, or reduce ownership percentages for members who do not contribute. This is especially important for Creek County businesses that may need equipment, inventory, vehicles, construction materials, payroll funding, or working capital. Owners should know in advance what happens if the business needs more money. Member duties and work expectations. Many business disputes happen because owners have different expectations about work. One owner may believe both owners will work full-time. Another may believe their contribution was money, not labor. A good operating agreement should address each owner's role, duties, authority, and compensation. The agreement may also address whether owners can work for competitors, start similar businesses, take customers, use company property, or engage in outside business opportunities. These provisions should be tailored to the business and reviewed carefully. Buyout rights. A strong operating agreement should explain what happens if an owner wants to leave. Without buyout rules, the business may be stuck with an inactive owner, an angry former partner, or a person who still owns part of the company but no longer contributes. Buyout provisions may address how the ownership interest is valued, who can buy it, how payments will be made, whether discounts apply, and whether the departing owner remains bound by confidentiality or non-solicitation duties when appropriate. death, disability, divorce, or bankruptcy of an owner. The best operating agreements plan for difficult events before they happen. If an owner dies, becomes disabled, gets divorced, files bankruptcy, or has a creditor trying to reach their ownership interest, the company needs clear rules. Without planning, a deceased owner's heirs, a divorcing spouse, or a creditor may become involved in the business. The agreement can restrict transfers, create purchase rights, and explain how the company will handle these events. Restrictions on transfers. Owners should not assume they can sell or transfer their ownership interest to anyone they choose. The other owners may not want a stranger, competitor, spouse, creditor, or family member suddenly involved in the company. A good operating agreement should restrict transfers and explain when approval is required. It should also define what rights an assignee receives and whether the assignee becomes a full member with voting and management rights. Dispute resolution. Disputes can happen in any business. A strong operating agreement should provide a path for resolving disagreements before they destroy the company. This may include meeting requirements, mediation, buy-sell procedures, tiebreaker provisions, or court remedies when necessary. For a 50-50 business, deadlock provisions are especially important. Without them, the owners may reach a point where neither can move the business forward. Tax classification and accounting. An operating agreement should coordinate with the company's tax treatment. An LLC may be taxed in different ways depending on the number of members and any tax elections made. Some LLCs may elect S-corporation tax treatment if they qualify. Others may be taxed as partnerships or disregarded entities. The agreement should address tax matters, accounting records, fiscal year, tax distributions, member compensation, reimbursements, and who communicates with the CPA. A lawyer should coordinate with the company's tax professional so the agreement matches the tax plan. Bank accounts and company records. The agreement should require the business to maintain separate bank accounts and proper records. Mixing personal and business money can create tax problems, accounting problems, owner disputes, and liability concerns. Good records help show that the LLC is a real separate business. The company should keep records of ownership, contributions, distributions, major decisions, loans, contracts, tax filings, and financial statements. Limits on authority. A good operating agreement should explain what owners and managers cannot do without approval. This may include borrowing money, pledging company assets, signing guarantees, making large purchases, hiring relatives, increasing salaries, selling major assets, entering unusual contracts, or changing the business. Limits on authority protect the company from surprise obligations. They also help owners understand when a decision must be approved before action is taken. Confidentiality and company property. Many businesses rely on customer lists, pricing information, trade secrets, vendor relationships, marketing plans, financial records, software, passwords, and internal procedures. The operating agreement should address confidentiality and ownership of company property. If an owner leaves, the agreement should explain what information must be returned, what records remain company property, and what restrictions apply to the departing owner's use of confidential information. Avoid generic forms that do not fit the business. A generic operating agreement may be better than nothing, but it may not address the real issues facing your business. A construction company, rental property LLC, family business, medical practice, trucking company, retail store, and professional service business may need different terms. The best operating agreement is tailored to the company's ownership, risk, tax plan, management structure, industry, and long-term goals. If you are forming an LLC, adding partners, buying into a business, or operating without a written agreement, speak with an Oklahoma business attorney.